There they are. Good evening, ladies and gentlemen. I would like to call this January meeting of the Quorum Court to order. This is the beginning of a new term, and this meeting will also serve as a reorganization meeting as well as the regular January meeting. I would like to make an announcement before we get started. We received a letter today from Mr. Jimmy Martis that he has resigned, so the Quorum Court will need to declare a vacancy in February. So I just wanted to let everyone know why he's not here tonight, but he has declared that he has resigned from the Quorum Court. I would like to welcome all of our returning JPs as well as our 5 new members. I think we've got a real interesting group of people, and I look forward to working with all of you. Tonight, the prayer and the pledge is going to be handled by Mr. Tom Lundstrom. Tom, if you will, please.
You join me in prayer. Our precious Heavenly Father, as we approach the throne of grace this evening, we simply ask that you would superintend this meeting. Give us the wisdom to make the decisions that are most beneficial to the people of Washington County. We especially ask tonight, Father, your protection of our law enforcement officers and also our men and women in the military service. The world becomes more and more dangerous as each day goes by, and we just ask that you would put your watch care over them in a very special way. We ask it in Christ's name and for his sake. Amen.
Amen.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, Tom. We're going to have roll call. We've got a message that Eva will be out. She had to leave town on business, and so if we could call the roll now, please.
Daniel Balls.
Present.
Harvey Bowman.
Here.
Rick Cochran.
Here.
Robert Dennis.
Here.
Lisa Ecke.
Here.
John Furman.
Here.
Ann Harbison.
Here.
Tom Lundstrom.
Here.
Eva Madison. Sue Madison.
Here.
Joel Maxwell.
Here.
Joe Patterson. Butch Pond.
Here.
Bill Ussery.
Here.
I gave Eva the privilege of announcing she wouldn't be here, but I forgot Joe, because Joe is in ET, so I'm not sure I feel sorry for him. The next thing we have in front of us is the adoption of the agenda. Do I have a motion to adopt the agenda?
So moved.
I have a motion and a second. All in favor, say aye.
Aye.
Opposed, same sign. The motion is adopted. Approval of the minutes is going to be the minutes of the December regular Quorum Court meeting has been distributed. Are there any corrections or additions to be made? Yes. Hit the middle one very gently.
Just touch it. That's gold.
There you go.
I wasn't at that meeting, and I would feel awkward voting on the minutes. I have no knowledge of what happened. So could you just record me as not voting, please?
Okay, sure.
Thank you.
Karen, would you get that down, please?
I make a motion that we approve the minutes as written.
Second.
I have a motion and a second. All in favor, say aye.
Aye.
Opposed, same sign. Okay. The next thing we have is number 6, is I have a resolution. Mr. Cochran, would you take this, please?
Had a request by one of our constituents to be able to have their member of their family solemnized. And Mr. Zaga, would you please read the ordinance for me?
A resolution authorizing Alfred Joe Main to solemnize the marriage of Samantha Renee Gooding and James Zachary Smith on January 16, 2015 in Washington County, Arkansas. Whereas, pursuant to Arkansas Code Annotated 9-11-213, the Quorum Court has the authority to appoint a person to solemnize a marriage, and whereas a request for such has been made as set out above. Now, therefore, be it resolved by the Quorum Court of the County of Washington, State of Arkansas, Article 1, Alfred Joe Main is authorized to solemnize the marriage of Samantha Renee Gooding and James Zachary Smith on January the 16th, 2015 in Washington County, Arkansas.
I move to pass.
I have a motion. I have a motion and a second. All in favor, say aye.
Aye.
All opposed, same sign. Thank you, Rick.
Thank you. Are they here this evening? There we go.
Would you stand up, please?
Yes, yes.
Congratulations and thank you. The next thing we have is number 7, powers and duties of the Quorum Court. Steve?
Thank you, Judge. Ladies and gentlemen, Quorum Court, members of the public, there are 3 broad areas that I understand Mr. Butler would always touch on, and I'm not one to reinvent the wheel if I don't have to. Those 3 broad areas that he touched on at reorganizational meetings include Freedom of Information Act, powers and duties of the Quorum Court, and solemnization of marriages. You should have had from me memos regarding FOI and the, and the marriage issue. What I'd like to do at this time is I'll begin with Freedom of Information Act, just very briefly, because I know you all can read, and I just want to touch on a summary of those things that I put in the memo. The Freedom of Information Act, broadly stated, covers 2 areas, open records and open meetings, with which government officials, especially elected officials, have to concern themselves. In open meetings, the idea and the principle, well, the underlying principle is on the same as both, that the public's business has to be conducted in public. And that means that what you do and how you make your decisions, the deliberations you come to, the way you make county policy, the discussions you have about county policy should be in a way that is accessible to the public, that they understand what you do, they have the ability to comment, to criticize, to question, to clarify when it's necessary to do that, or when they just decide to do that. So sometimes open records and open meetings sort of become a little muddled in terms of which one is which, and if there's not a distinction, the idea is that if it's a question, generally speaking, about whether you should do something in public, whether you ought to disclose, then the answer is yes. If you have to think about it, generally the answer is yes. I am available. There are exceptions to the Freedom of Information Act and exclusions from the Freedom of Information Act, things that you are not supposed to disclose, say HIPAA-protected information that may have been generated by a government, and things that are accepted from disclosure or immediate notice to the public, like open criminal investigations. In general, the idea, though, is that when you do something that affects county business, you have to do it in public. Now, what's county business? The court takes the Arkansas Supreme Court has taken a very broad definition of what county business is. Anything that touches on county policy, not just the ordinances and resolutions you pass, county policy, the performance of county officials or county employees, what we ought to do, what we're thinking about doing, maybe about a certain county road, or something the county judge has done in the county court. All of those things are county business. And if, again, you have to think about it, is this county business or not, then the answer is that it probably is. In my memo, I wanted to touch on just a couple of things very briefly. I have never believed that you can't communicate with each other in writing when that is not as sort of a back and forth type of thing where you're responding to each other, say on a text message or instant messaging or Skype or something like that, or emails that you're responding to instantly. Because what you do if you do that, okay, is you kind of begin to have an electronic meeting that the public is not aware of and hasn't been notified of, and the press doesn't have notice of. I don't believe you can't write each other a letter as long as that letter is made available to the public. I don't believe you can't send each other emails as long as you're not beginning this sort of real-time conversation, again, as long as that email is made available to the public. And what I have asked you to do and what I advise you to do is when you write to each other, if you choose to do that, that you make that writing available to the Quorum Court coordinator, and in general you copy it to the press so they know what's going on. I do advise you against talking to each other on the phone about county business. I advise you against talking to each other in person about county business, just for the simple reason that you don't want to create the appearance, if nothing else, that you're not doing business in public. Yes, the Freedom of Information Act, therefore, puts constraints on you as Quorum Court members, as justices of the peace, that maybe other lawmakers don't necessarily face. But it is incumbent upon you to make sure that you do the public's business in public. As I said in my memo to you, the natural question is, what happens if I violate the Freedom of Information Act? Well, There is a criminal penalty. It's a Class C misdemeanor, and a Class C misdemeanor is punishable by up to 30 days in jail and up to a $500 fine. I think the more important thing than that is that the mental state that you have to violate the Freedom of Information Act is negligently. In other words, and I define that for you in the memo, you don't even have to intend or mean to do it. If you were negligent in violating the Freedom of Information Act and you found a prosecutor who was willing to prosecute you for that violation, then potentially you could face 30 days in jail and $500 fine. Now, I'm not meaning to intimidate you by that. I think it's just my job and incumbent upon me to explain the ramifications and the possible sanctions, if you will, for something like that. But I think the real hook or the real hammer, if you will, for violations of the Freedom of Information Act is if there is an ordinance found to be passed or a resolution found to be passed by a court in violation of FOI, then it's void. The court can void that ordinance, can void that policy, can void that resolution. And it seems to me that y'all do an awful lot of hard work up here that you don't want to throw away on something silly like that. And with that, I would ask Brenda Blagg, a longtime journalist and someone for whom I have an awful lot of respect, to come to the hot seat and discuss more.
We appreciate her time. She's got a birthday tonight for a 9-year-old nephew, so we certainly want to let her.
Important things going on outside of here.
Thank you, Brenda.
I'm glad to be here. For those of you who are new to the court and who I haven't had a chance to meet, I did cover the county government for 29 years. And that was through the transition from the very old kind of quorum court into the new one. And, you know, it's new since, 90s, 80s, I don't remember. But it's a different critter than it used to be. And, of course, I've enjoyed watching the transition. And part of that transition was learning to live within the FOI. I've been an advocate because when I was in college, that law was passed. This particular law, the 1967 version, was passed while I was a student, and I became an advocate then. I'm still an active member of the FOI Coalition, which is a statewide organization that does what we can to keep the law strong. The booklet that you have is a year older than the one I have here, I think. These get redone after every legislative session because inevitably the legislature does something that affects the law, and we have to make some change in it. But I'm going to give you a tip that will help you to find provisions in this law on your own so that you don't have to bother Steve. But if you will go to the Arkansas Press Association website, which is arkansaspress.org, on its opening page you'll see this little book. You can download it, put it on your computer, and then you can search anything you want to find in the book. And there are a lot of court cases, a lot of Attorney General's opinions, and just some questions and answers in this booklet that will answer most of the things you're going to come across. Because in nearly 50 years of experience now with this law, we've had almost everything happen somewhere, someplace. And we're still trying to, make sure it gets complied with. My main purpose here tonight is just to encourage you to remember what it was like not to be inside the government, to be on the outside looking in. I know that some of you are here probably because some friend or neighbor badgered you into running. Some of you are here because you had an issue with something the Quorum Court was considering that you were very interested in, and you thought, I can contribute there. I'm going to get on that court and I'm going to have my say. Well, there are thousands of people out there in this county who are interested in what you do. But unless you let them be a part of it, they don't know how to respond to you or how to tell you that you're doing well or that you're doing just a little bit wrong or that you're doing way wrong and that they're going to change you next time, by George, because they don't like how you acted. Your best defense for anything that you do is transparency. This law ensures it. And I assure there are people like me out here who try to use it like a hammer to make sure that you don't forget that. But it ought to be something you want to do, because It makes it better for your people. It makes it better for you in the long haul. Again, try to remember those people looking in from the outside who aren't part of the government, who weren't part of the decisions that led up to this. If your committee meets and you have an open discussion and they have an invitation to come, that's great. The reporter may be there covering, he may not be, but if he isn't, they still have the right to come themselves. Everything in this law is written for the public in general and not for the press. Some people mistakenly think it is, but it is for the people of Arkansas. Their rights are exactly the same as mine as a journalist. I want to give you my phone number because since Steve's not available for some reason, I'm not an attorney, but I can certainly guide you through this little booklet because I have thumbed its pages and helped create some of what's in it. But my home phone number is 443-5702, and I'm semi-retired, so I'm fairly easy to find. If you have a question and I can help you, I will do that, not only for you, but for anybody who might be listening out there in the public who wants a hand in finding out how to get access to their government. The best advice I heard from Steve was basically a rule I followed all my life. When in doubt, don't. Basically. If you think there's a question about whether you ought to be meeting privately with someone, you probably shouldn't. There are ways that you can communicate in writing. Again, what you write is open to public inspection because it's a public record. And don't be surprised if I or somebody else asks you to see it. But it's really a question of conscience. And that's something that you have to determine for yourself, that you want to follow this law. Nobody can be with you every day of the week. I can't make sure that the two of you aren't meeting somewhere and lining out a plan of action and trying to do the business of the county behind the public's back. Nobody can really do that. Now, if we do find out about it, you could get sued, you could get prosecuted. But the truth is, it's a matter of conscience more than anything else. And I hope you all do right. If I can ever be of help, I'm glad to do it. Like I said, I'm available. If I can answer questions, I'll help you. If I don't know an answer, I know a lot of people who might. A lot of lawyers who work this issue all the time. So thank you very much.
Thank you, Brenda.
We do. I'm sorry. Yes, go ahead, Sue.
Mm-hmm.
Thank you, Madam Chair. Steve said that we could email each other as long as we copied the press. Who would that be?
Well, the truth is that the law puts a burden on media people as well, in the sense that we need to actually request that we be notified. I mean, you can't just sit down and think, all right, who is the press? Does the New York Times care? Does the Little Rock edition of the Gazette care that I'm having a meeting or whatever? Probably not, but in general, a paper like the one locally should have a request on file that says we want to be notified of special and regular meetings. And if I'm a good politician sitting in one of these county offices, I don't need that letter. I'm going to make sure that anybody who actively covers the public body is getting that notice. Karen always did that. She would find, if anybody made a request anytime to come cover or find out about a meeting, they would find out about the next one too, because Karen made sure they did. And that's good government. That's just letting people hear from you.
So then Karen's office knows who to contact if we wanted to do that?
Yes.
Okay, thank you.
Any other questions that I can answer? Well, good luck to you all. It's a challenge to be in the job jury, and I know I've watched it work for a long time.
Brenda, thank you so much. And
Glad to be here.
you have our respect, and thanks for coming tonight.
Thank you, Brenda.
Pardon me. I'm going to move on now to powers and duties of the court. The memo you have in front of you from me lists statutory duties, and much like the Freedom of Information Act brief I just gave you, it is not nearly all-inclusive. But what you'll find at Arkansas Code Annotated 14-14-802 is a broad thumbnail statutory grant of authority to you within the context of Amendment 55, which reorganized county government, I believe, in the late 70s. And the essence of this is what you are mandated to do. I listed those duties first, and the two main duties or the two main sets of duties are taking care of things like the administration of justice, law enforcement, the administration of real and personal property taxes, managing the court and public records, and then the big one that the Quorum Court has, and the big power the Quorum Court has, is levying of taxes and making appropriations that you do through budget process in the fall, generally speaking. Of course, depends on how often budget and finance meets. But your jobs, those are your mandatory jobs. And then beyond that, your discretionary functions are listed on the second page of that memo, beginning at about the 10th line of the second page. What you may do and how you may do it. And even that is not all-inclusive. You'll find at the end of that particular statutory section one of those elastic clauses and basically the idea is as long as it's not unconstitutional or superseded by some state or federal law, you may do it as a quorum court. It's within your purview to set policy and make the laws that govern the county. That's a very brief thumbnail sketch of what you may do as a quorum court. I'd also like to talk briefly about meeting procedure. The court has constituted itself many years ago as a body that follows the Roberts Rules of Order. You should have before you a summary of Roberts Rules that talk about motions and things that have to be, what has to be brought to the chair's attention, what kind of votes various motions take to pass, and the like. Roberts Rules are modified slightly by things like procedural guides from the legislature when it comes to the quorum court. For example, the difference between passing an appropriations ordinance, which may be passed on the first reading, and other types of ordinances which don't have emergency clauses, which take 3 readings to pass. Although frequently, as those of you who are new to the court will find probably tonight, perhaps tonight, the rules are suspended very frequently, and ordinances and resolutions are placed on second and third reading if they are not particularly controversial and read by title only, and then we proceed to vote on them that night, the first night they're brought up. Certain types of ordinances take a 2/3 vote. Anything with an emergency clause in it takes a 2/3 vote to approve at least the emergency clause. It can be passed later without the emergency clause, without that 2/3 vote, a simple majority. In general, though, your business will be done by having at least 8 votes in the affirmative. And if you do not have 8 votes in the affirmative, in other words, a present vote procedurally counts as a no vote or an abstention counts as a no vote, then the ordinance or the resolution will not pass in general. You also, as the judge will get into a little bit later, you will be on committees. Generally speaking, the way the Washington County Quorum Court does business, this is not always true, but most ordinances and resolutions begin in committee. You will have regular committee meetings. The judge will talk about the assignments she's made on those, and most ordinances begin in committee. Sometimes they make it out of the committee, and sometimes they don't. What you'll have is one of the things that you need to realize if you're new also, though, is this. If your committee to whom you brought your ordinance, if you're on the committee or not, but you brought it to that particular committee, says, you know what, we're not going to give this to the court with a due pass recommendation. We're going to try to kill it. You, as a quorum court member, as a justice of the peace, have the right to bring it around the committee to the court and present it anyway. You certainly can do that. And I've, in my experience, have seen that done a couple times. Not frequent. Generally speaking, and I think the veterans of the court will tell you this, we try to respect the committee process because that's where most of the heavy lifting is done. Okay? But one of the things you need to know about me, too, is I don't make policy for the county. I now advise the county on trying to stay out of the unconstitutional ditch and the illegal ditch. And if you ask me a question, I'll try to answer it the best I can. But If the question is this the right thing to do for the county, ultimately, that's on the 15 elected members of this body. Very briefly, one of the best things I found about being a justice of the peace was I got to marry people. It's one of the joys that this job brought, and sometimes it was the only joy the job brought. In that, there are attorney general's opinions. You can marry anyone in Arkansas as an elected justice of the peace, and if you have been anywhere in Arkansas, and if you have been elected to 2 terms or served 2 terms, you may, even after you're off the quorum court, marry anyone within the state of Arkansas. What you need to know is, unfortunately, you're not allowed to collect a fee at least as long as you're on the quorum court. The Attorney General has issued a number of opinions, one of which I attached to my memo about solemnizing marriages, opining, and I find real logic in that opinion, that you are not allowed to collect a fee. So I recommend to you that you don't even let a white envelope change hands at a wedding if you are performing it, to avoid the appearance. Sign the marriage license. I have no personal problem if the bride and groom invite you to dinner and, pay your dinner, or set a place for you at the reception. I think that's wonderful, and I don't think that that's in the meaning of a fee. If dinner happens to be, at a rooftop restaurant in St. Louis, maybe we're going to have a different opinion about that. But in general, don't take any pecuniary reward for marrying people while you're on the court, and do it because it's fun and it's a great public service. And with that, Judge, I'll open it up to questions for me.
Tom?
Steve, I am both a JP and an ordained minister. I have never married anybody as a justice of the peace. When I signed the marriage license, I signed it Tom Lundstrom, minister, and I put the book, page, and so forth on the marriage license. I have never charged for a marriage, but I do say if you want to give a contribution to the church that I pastor, you are welcome to do so. And they will give me money if they desire, and I take it and give it to the church. I think I can do that without any question, but I don't want any false accusations made that as a JP I'm taking money, because I'm not marrying them as a JP. So I just want to make that public. Thank you.
And Tom, I don't think there's any issue with the scenario you just raised.
Yes, Lisa.
Are you able to say, if they are insistent about giving money for some reason, can you say, or can they say, can we give it to your favorite charity in your name? Is that permissible?
As long as you aren't taking money, as long as you're not taking money, and I have no heartburn with you saying give it to, the Salvation Army or whomever you feel like you need it to give to. The idea is you are not to be personally compensated for performing a marriage. Anything else?
Sue?
Before I jump ahead here, have you concluded your remarks about FOIA and the court?
Yes, ma'am, I have.
Okay. Well, this is just a procedural question. And, for instance, how was our seating determined tonight? Those kinds of nitty-gritty issues that affect the court, how was that determined?
Alphabetical.
By whom?
By me.
Okay. Is there statutory authority for that, Steve?
In general, the presiding officer, and I can't quote you the statute, Sue, but the presiding officer can arrange the room, essentially.
Okay. Would you check and see if there is statutory authority for that? And if there's not, if there is no statutory authority for that, would that fall to one of the prerogatives of the court then?
I'll get you a yes.
Okay. Very good. Thank you. And I don't have any problems with alphabetical or by age or however you want to do it. I just want to know procedurally, because there are certain legislative functions that belong to the legislative body. Thank you.
Anyone else? Okay. Next thing we are having to come up will be the review of the quorum court committees. Karen Would you got some forms that you'll please distribute for me? I've got it. Thank you. The first page you have is the committee assignments. The second thing you have in front of you is the description of each committee. Then the third thing you have is the committee dates that Karen has put down for you. After the committee meets and they elect their chair, if they want to change the date, they certainly can do so. We just need a date set up so that we can follow procedure to be able to get the committee started. Do I have a motion to confirm the first committee dates that we've got set?
So moved.
Do I have a second?
Second.
All in favor say aye. Aye. Opposed, same sign. Okay, Karen, your committee dates are final until we get something started. Next thing we have here is selection of representatives to the Quorum Court, to the Arkansas Association and the Quorum Court Association. The Quorum Court needs to select a JP to serve as its representative to the Arkansas Association. Do I have a nomination? Shirley, go ahead.
I nominate Sue Madison for that responsibility.
Okay.
Decline that nomination.
Okay.
Thank you.
Okay.
I've grown weary of trips to Little Rock long ago.
Boy, I know that feeling. Anyone else got a nomination? Rick?
Judge, I know Eve is not here, and he says served us well for the last 2 years. I wonder if she would be considering Sue. Do you know if she would consider doing for another 2 years?
Don't really think I should speak for her.
Okay.
I'll tell you what we can do. If you want to wait till Eva is here, then we can bring it up next. Can we bring it up at the next meeting, Karen?
Okay.
Yeah, okay, yeah. So let's
true.
wait and see if we can get the other two here, and then we'll bring it up next month at our next
Do we
meeting.
need a motion for that?
Yeah, let's go ahead and make a motion.
Okay, I move that we postpone the assignment of the position till the next Quorum Court meeting.
Second.
I have a motion and a second. Any discussion on it? All in favor?
Aye.
Opposed, same sign. Okay, we'll just wait till next month, and then we'll do it after we have, and we may have a new member next month. So we'll wait and see what goes on there, because I know that probably won't get done until February, but at least we'll look and see if we can get something going. Thank you. Yes, sir.
Judge, I know that we all probably know that the state legislature has given you the authority to to limit the size of committees.
Yes, sir.
You know, I guess one of the things that really come out to me is, like Steve said a while ago, the heavy lifting of this business is in the committees. And you know, my first term here, we were already doing the budget of a whole for the budget and finance. And you know, as I thought about that a lot, every one of us had the responsibility to make a contribution to managing the finances of this county. If we are not on that committee, we can make comments, but we can't vote. And I believe there's a great deal of difference between voting and making a comment. And by the time we get to the final approval of the committee's reports, basically it becomes kind of a rubber stamp kind of situation. And I'm going to appeal to you to reverse your position here on limiting the number of people on the budget and finance to 7, and allow us all to serve on that committee, because I think it's incumbent on every one of us to make our opinions known and our votes cast. I dare say you wouldn't be happy with the next election being able to go in and share a comment without being able to vote. And that's the thing that I oppose here on this limiting of the budget and finance to 7 people instead of 15.
Thank you, but I am going to leave it 7, but I do appreciate you. Thank you. Yes.
Thank you, Madam Chairman. Let me ask Steve a question, because I had done a little bit of research on this myself, and not as an attorney, but just in casual conversation with a close friend in Little Rock who is. The act that the legislature passed giving the county judge the authority to determine membership of these of a committee of the whole took effect after our county had already passed an ordinance establishing our finance committee as a committee of the whole. And this friend was actually looking at one of the recent ballot issues, and a court opinion had said the legislature is presumed to be acting prospectively unless they specifically say they are acting retroactively. But it seems that you all have determined to apply this new statute retroactively. If I said that where you can understand what I'm trying to say.
I think I understand what you're saying, Sue, and my 2 points about that. I don't believe this is a retroactive statute because, in the first place, this is a new court. This is a brand new court with brand new members. So I don't believe it applies retroactively. The second point of that is whether the court ordinance, pardon me, the ordinance passed by the county court, the county quorum court, in organizing the committee of the whole, is displaced by a state statute. And in my opinion, in this case, it is, because the language in the statute is that the committee, I'm looking at it now, a regular or special committee of the quorum court shall not consist of more than a quorum of the whole body without the consent of the county judge. To me, that's in the present. That's right now. By any language, any rule of statutory construction. I believe it applies to this court for those 2 reasons.
Have our committees that were established by that ordinance, do they not continue unless the ordinance is changed? I mean, we've got county services, public works, personnel. We've got all of these committees that were established by that ordinance, and they seemed to the assumption seems to be they have continued because we haven't taken any new action.
And I would agree with that in terms of the names of the committees and their assigned duties. I'm not sure beyond that if you're talking about budget committee of the whole no longer being on that list. Is that what I understand you to ask me about?
No action has been taken on these committees since the ordinance was passed, and the assumption is they have continued. So I don't understand your logic that says, but not one of them. The finance does not continue as it was constituted under the ordinance.
Oh, I see what you're saying. The reason is that the state law, in my opinion, displaced or trumped that ordinance.
Okay, I'll try to get that opinion for you. Thank you.
Yes.
Judge, would you share with us the rationale of selecting only 7 people for this committee instead of having all of us work on that committee?
I feel like there was an awful lot of time that was taken. I feel like there was a lot of expenditures, a lot of money that was spent that, I'm just going to come right out and say it. The quorum court went $95,000 over their budget this last year. That was a pretty tough thing to call. So I think maybe that's one of the reasons, because $95,000 with all the meetings they had, I feel like 7 members can make decisions and get things done. And, you need to understand, even though you're not voting, every member is allowed to come to the meetings. They're allowed to make their opinions, and then they know what's going on when you go to the quorum court, the regular meeting.
I don't think there's any question we know what's going on.
Okay, thank you.
But those committees do pass on things that tend to get rubber stamped, and not being able to vote in that process makes a great deal of difference. And by the time the quorum court meets to approve those, a lot of the details have fallen by the wayside.
I
and are not
understand where
included.
you're coming from, but I thank you.
Well, one other thing I'd like to say. I think that my compensation last year was about $10,000 with everything included. We've got 15 people on that court. That means $150,000 paid to the JPs with all of the intellect and experiences that we bring to the deal to look at cost for the quorum court meetings of $150,000. I dare say it brings a great deal of value to the county. And to not utilize that, in addition, we had a very difficult budget situation this last year. Very difficult because of all the finance pressure. And that finance pressure created most of the time that was consumed in that process. And I think to eliminate the contributions of the entire group in this process is really less than favorable for the county.
Thank you. Rick, did you? Yeah.
I just wanted to comment that there have been several times that I have been in the meeting but not seated on the committee and brought up an idea that was pertinent to the subject at hand and actually could not make the motion to amend, but it was done by one of the members of the committee. So actually our involvement here, even though we're not a voting member of the committee, is still very important and can have a positive impact regardless of the names on the committee or not.
Thank you, Rick.
Thank you.
Yes, Tom.
I just have a very quick comment, but I think discussing it tonight is basically a moot point because what is, it is. But I do believe that what the state legislature did is a violation of the doctrine of separation of powers. And every level of government that I'm aware of, the legislative body makes their own decisions regarding committees. The governor doesn't appoint committees in Little Rock. President doesn't do it in Washington, D.C. That's been a long time part of our government process nationwide. And the thing to do is go to Little Rock and try to get it changed back the way it ought to be. And so that'll be next year. Thank you.
Sue, did you have your hand up?
Ma'am. Thank you, Madam Chair. I'd just like to point out that your desire to save $95,000 is being negated by the statement that we're all able to attend the committees anyway and give our input, even though to a muted degree. It's not going to save any money if we're all still going to go to finance. It just means some of us will have less influence and less ability to work through the problems of this county's budget. And I think the work that was done last year was a lot of hard work that was a very good result for the county. There was significant savings, and I think it's important that we continue to work for savings and that all of us continue to do that. And it was important for the Finance Committee to have everybody there. I went to a lot of those meetings, and I appreciated the hard work. And I think this is a setback for the county.
Thank you. Anyone else? Thank you. The next thing we have is a report for the county judge. The first thing you'll have in front of you is the property disposal report. That's something that I just needed to make you aware of because what happens here, one year we forgot to do this and we had to call a special meeting. This is just old property that we have to get rid of, but I do have to make you aware of it. And I am just looking for a motion to move this forward to approve all old property for disposal for disposing of.
I so move.
I have a motion as a second. Any discussion? All in favor say aye. Aye. Opposed, same sign. The next time I'm going to ask Mr. Short to come forward. I'm going to ask him to give a road report for me. I've got several things to talk about, and my voice is not the very best.
Thank you, Judge. For those of you that I have not had the pleasure of meeting, my name is Dan Short, and I serve as the Chief of Staff for Judge Edwards. We have about 15 different departments, and I assist her in the administration and the management of those departments. I'm a poor substitute tonight because typically for this report, Sean Strum, who is the Assistant Road Superintendent, would be here to provide the information. I have a cheat sheet to read from, so I'm going to give you the information that I have from Sean. And this is about the Washington County Road Department for 2014. For 2014, we re-chip and sealed approximately 60 miles of road. The reseal on the chip and seal road is done about every 7 years, so typically we will try to get about 50 or 60 miles every year. We turned 4.5 miles of gravel road into a hard surface of some kind. 2.7 was chip and seal, and a 1.8 was asphalt. And then we overlaid about 2.9 miles of asphalt in addition to that. The next major event for us in 2014 was the beginning to replace the Stonewall Bridge over the Muddy Fork of the Illinois River. New construction right now, we're working on County Road 1090 and 199 near Round Mountain, and we're preparing those road beds for chip and seal during this year. We're also working on Wolf Track Road out near Summers, southwest of Summers, and we're preparing that road bed for chip and seal this year. We're continuing to work on Smoky Bear. Smoky Bear is off of the Black Oak Road, and we're widening that area due to the request of some of the citizens in that area who felt like it was necessary for the buses that come out there for the school children. I think there are two different schools that serve that road. And the road was narrow in some spots, and so we've worked through that issue and are in the process of widening that road. It's not going to be a chip and seal road at this time. It's just going to be a better gravel road. I think most of you probably know by now we've closed 2 bridges in Washington County this week. On the 12th, we closed Orr Bridge, which is west of 265. And on the 13th, we closed the Woolsey Bridge, adjacent to Highway 71, south of West Fork. The reason for both of those closings was a safety factor. We have looked at those structures for the last year, and the judge has made the decision that we could no longer let the public drive on those roads, on those bridges. And so those have been closed. And the Stonewall Bridge I alluded to earlier, we'll be starting the east side end walls and wing walls as soon as the weather permits. Right now we have the head wall and the wing walls on the other side and the 2 piers in the middle finished. So that's basically our road report for 2014 going into 2015. Yes, ma'am?
Yes, go ahead, Sue.
Thank you. I would like to know what changes have been made at the road department in response to the allegations of inappropriate construction. For instance, have we changed how we bend rebar? Are we using epoxy to firmly establish rebar in already poured concrete? The article that Mr. Holtmeyer wrote in the paper about the county roads left me with quite a few questions as to their construction on bridges, and left me less than assured that we are following proper procedures.
You want Steve to answer that?
Well, he may advise if he wants to. I'm a little bit hesitant to respond specifically in a situation where a lawsuit has been brought. I can tell you we strive every day to improve our methods, and if methods are identified to us that we're lacking in, we're going to take every step that we can to improve.
Well, it concerns me that we've just had 2 bridges closed because of safety, and the conclusion I jump to is, have we been following proper maintenance guidelines? If we are not following the plans that the engineers whom we pay for the plans, if we're not following those plans, are we following the plans for proper maintenance?
Well, you're assuming we didn't follow the plans that the engineers laid out. And I can't say that that's a true statement.
Okay. Well, let me ask you a sort of a separate question. Could you tell me why I had to file an FOI request to get the name of the engineer that did the plans for Harvey Dowell?
Wasn't necessary to file an FOI. If you had called me, I would have given it to you.
I called. I was in Karen's office and asked her. She and George weren't sure. They both said Sean would know. She called Sean. Sean would not give me that information unless I came to the road department. And I told him I had a very busy schedule that day and I was not coming to the road department. And he wouldn't give it to me.
Well, I apologize for that. If you'd have gotten hold of me, I would have given you the information. I don't see any reason for not providing that information.
I don't see any reason for me to have to jump from one elected person or from one county official to the next just to get a simple answer to a question that he knew the answer to.
I agree with you.
Well, it was a little uncomfortable to have to file an FOI request with my own county.
You have my apologies.
Okay. Well,
John.
I would like to know what happened to the extra yards of concrete that we're missing. Mr. Holtmeyer's article didn't cover that. Apparently 130 yards of concrete were poured for a 60-yard job. 70 yards of missing concrete went somewhere, or else we paid for concrete we didn't get.
I doubt that happened.
Well, are you all investigating these allegations and coming up with the answers to
Yes,
whether
ma'am.
they're accurate or not?
Yes, we're looking into all of these allegations.
When will this court have some answers? Because the lawsuit's about whistleblower and freedom of speech.
Yeah, I think probably we'll be able to be more forthcoming about the information once the lawsuit is complete. Again, I hesitate to talk too much about what has been charged against us. In essence, given the plaintiff 2 bites at the apple, if you would, it's not something that I feel comfortable talking about since their lawyers have been involved in this.
Well, to me, we're talking about spending public tax dollars
Absolutely.
and perhaps public safety.
Yes, sir. I have the utmost faith in the construction of the most recent bridge, the Harvey Dowell Bridge, and the bridge that we're doing, Stonewall Bridge now. I would have no compunction in letting my family drive over the Harvey Dowell Bridge.
The state inspector, Mr. Ball, that I talked to, said they do their ratings based on the engineering plans, and they assume they are built as the plans show.
Yes, ma'am.
I'm going to have to call attention to this. I'm going to ask my attorney here to speak, please.
Okay.
Steve?
Thank you, Judge. In this instance, I want to be clear about something. Dan's point about the fact that this is in litigation and that and Sue's point that we are talking about public dollars are both well taken. The issue is how much we talk about things that are in litigation. And as the county's attorney, I wouldn't be doing my job for you, the county, and this court, the body that appropriates the money for the county, if I didn't tell you that it's never wise to start talking about matters that are directly under litigation while that litigation's going on for a variety of reasons. That I'll be happy to articulate more in depth at this or a later time. But I'll tell you this, the point that we are talking about substantial amounts of public money is true. This lawsuit that is filed seeks substantial amounts of public money as well, which is all the more reason to be careful and safeguard what we say about things that are under litigation, including the specific plans for that bridge and whether or not any deviation was taken from them at any point in time. Those are important matters and they should be discussed in public. But at some point in time, you also have to realize you're being sued, and the county is being sued as a derivative of those questions right now. Thank you. That's all I have.
John?
Thank you. Dan, you know, I mean, it's more of a personal question, but on the Woolsey Bridge, can we still ride our bikes over it? Because
The Woolsey?
I mean,
No.
That's a good question. I understand.
It's totally
But
blocked off?
It's totally blocked. We have mounds of dirt on both ends of the bridge, and we also have guardrails up on the hard stand going up to the bridge. So it's totally, completely blocked.
And, you know, Dan, you might want to put that in the paper because there are a lot of people that ride out there and then you get cut off and you have to go way back around? I mean, I know it sounds a little silly, you know.
We may not be able to keep people from doing that, but there are sufficient signage out there that says this road is closed, this bridge is
Right.
closed. It's not for public consumption.
Okay. All right.
If something happens and they get hurt, then the county's not liable. Because
Right.
we're doing everything we can for safety.
Sure. Okay. Well, I just wanted clarification.
Yes.
Thank you.
And we realize it's an inconvenience to a lot of people that use those bridges. And hopefully we'll be able to get started on bringing those bridges down and replace them in the near future.
I hope so too.
Tom, did you want to ask Dan something?
Well, I just wondered if we had any more current information on where the state is with that Woolsey project.
Nothing at this point. Today, the judge and I talked about maybe taking a delegation down to the Highway Department in the near future of concerned citizens to talk about the speed with which they may help us get started on that project.
I bring that up mainly because of the new people on the court may not be aware that the state is, I think, doing some design issues
Yes,
and
they
so
are.
forth on that bridge. And it's the old bridge. That bridge was constructed in 1925, I believe.
That's correct.
And Sue, that may help with some of your questions. The two bridges that are closed are almost 100 years old.
Yes.
They're not the new bridges that have been recently constructed. But I just wanted the new members to know something about what the state was doing with us on that. Thank you.
I need to make a comment. What happened? We closed one bridge and then we closed the other. Whenever the state comes up here to do an inspection, they check several bridges, and they made us aware of some of the major problems in these two bridges, which made me very uncomfortable. So to protect my people, to protect my taxpayers and the public, I felt like it's the best thing to do for the public was to close those two bridges. It's not something I wanted to do. I went to West Fork the other night. Dan and one of my road people went to Brentwood to speak to the people, to let them know in the community what we're doing, and they were most appreciative. And some of them said they were really glad to see us do that because they knew that someone was going to get hurt within time. So I just wanted to make that clear. I think the Highway Department is really looking at the Woolsey Bridge. We found out that they do have the survey done, so we just have hopes that maybe this will move forward. Now, sometimes drastic steps cause drastic things, so maybe they'll move forward and we'll get something done with it. Thank you all for understanding. I appreciate it. Dan, anything else?
I would just like to offer my services to anyone on the Quorum Court. The judge's administration covers the supervision, I think, currently of 202 county employees. And that those 202 county employees work under about 15 different departments. And so you can imagine with that many different departments and all having different missions and going different directions, we have a lot going on every day. But if anybody on the Quorum Court needs anything from any of those departments and do not get it, please contact me and let me know. I'll see that you get the information that you're looking for. I have an office that I stay in here in the courthouse part of the week. Part of the week I'm down at the road department. But the ladies that answer the phone at both of those locations will be able to reach me regardless of where I am, whether I'm out in the field or which office I'm in. And if I don't know the answer, I'll make sure you get the answer.
Yes, Butch.
I wanted to make a comment. It's kind of coming off of what Dan said. The Harville-Dow Bridge is in my district. I'm proud of that bridge. People have been waiting for it for a long time. I'm not hesitant about driving across it, and I couldn't see any reason any 80,000-pound gross weight vehicle could not cross that bridge. I appreciate the job that the road department does, and I'm just glad it's there. And if they used a little extra concrete in those stem walls, that's not going to bother me at all. Thank you.
Thank you, Butch. Any other comments? Thank you, Dan.
Yes, ma'am.
The next thing we have is an ordinance authorizing the county judge to enter into the contract for service with the Association of Arkansas Counties. Butch?
Yes.
Thank you, Butch. An ordinance authorizing the county judge to enter into contract for services with the Association of Arkansas Counties. Whereas Washington County is a member of the Association of Arkansas Counties, and whereas membership provides services to the county such as legislative representation, general research, training, various public conferences, and the right to participate in any one of 4 benefit programs, and whereas pursuant to Arkansas Code Annotated 14-20-107, the Quorum Court must authorize participation in the association. Now therefore be it ordained by the Quorum Court of Washington County, Arkansas, Article 1, the county judge is hereby authorized to sign the contract for the year 2015 for services of the association.
This is a must. We need this contract for risk management. Move to read a second time by title only. Suspend the rules and read by second.
I have a motion to suspend the rules. I have a second. All in favor say aye. Aye. Opposed, same sign. Steve?
An ordinance authorizing the county judge to enter into a contract for services with the Association of Arkansas Counties.
Move to suspend the rules and read a third time by title only.
Have a motion and a second. All in favor say aye.
Aye.
Opposed, same sign.
An ordinance authorizing the county judge to enter into a contract for services with the Association of Arkansas Counties.
Move to pass 11.1.
Second.
Have a motion and a second. Any discussion? Yes.
I looked up 14-20-107, and it says it shall be equal to 1% of the revenue received from the county aid fund. Is that what where the money comes from? Is that what the amount is, and how much is the amount? How much is in the county aid fund from last year?
I don't know the answer to that
Cheryl,
question.
do you know?
Well, it says the amount we pay shall be equal to 1% of the revenue received by the county from the county aid fund. Who does the math on that?
We will get you the information.
Bobby, do you know?
Turn back.
County aid fund is what the statute
It says county aid fund. You're my money man.
The general turnback. We get about 14,000 a month. And if that's what you're looking for.
Will you look this up for Sue and get it to her, please?
How
Okay,
much money
thanks.
are we talking about?
I don't know.
That we're going to pay the county, the Association of Counties?
It's on 11.2 is the amount.
Second page.
11.2 says the
Okay,
amount
there it is,
that the
Sue.
membership dues is. $5,933.
No, it's not. $5,933.
So it's almost $6,000.
Yes.
And in return for that, all we get is the ability to buy insurance, basically? I mean, I've seen the Association of Counties legislative packet. It's a huge packet of bills, and they hardly ever talk to anybody about any of those bills. I think I've had input from the Association of Counties on maybe 2 bills the whole time I was down there, and one of them was that one about letting people that have been a JP 2 terms continue to marry. And they didn't even have that bill organized enough to have it. They had to come rewrite a shell bill I had to get that in time. I don't know that they do very much legislative work for us. Or maybe they do work for the county that I'm not aware of.
Well, like I say, I can't tell you what all goes on, but I do know it's an important function. They provide insurance for a lot of the counties, but we're self-insured, so we don't use their insurance, like our health insurance. We have our own health insurance.
So what Butch said about our risk management comes through them is not correct?
Yes, it does come through them.
It does?
Yes, yes.
Okay, so we buy one kind of insurance from them.
Yes, the risk management, yeah.
And what's that insure?
Judge, if I may answer that
Sure,
question.
please.
Risk management does, amongst other things, pays the attorneys that do defend us in multiple 1983 lawsuits from the jail. They're also currently working on the lawsuit referred to earlier tonight, outside counsel. They're also looking at they also handle claims on various other anything that's related to 1983 actions they handle. 1983, 42 United States Code 1983, any alleged civil rights violation by the county. And if we were to lose at court and pay a judgment, or they were to pay a claim, that's where it would come from.
Is that risk management insurance included in the $6,000 that we pay them, or we pay that extra?
That's another question I don't know the answer to. I know that is a service the association pays for us. It's beyond that $6,000 according to Cheryl.
Okay. Well, let me ask you, if we pass this and this it's not 1% of the whatever the county aid fund is, what happens?
I don't know. This is just the way they've always turned us in, and Bobby with the treasurer and Cheryl, so.
My abiding suspicion is that, and it is only a suspicion, is that we will not be a contributing member of the Association of Arkansas Counties. I don't know whether that would put our risk management funds at risk. In other words, if this is a conditioned precedent to, I apologize, I've got.
No, I thought maybe
It's
mine
because-
we've got too many mics on. Okay.
If this is if belonging to the association through this particular program is a conditioned precedent to belonging to the risk management pool, if it is, it's important enough in my mind that certainly we need to do it. A recommendation only. Again, y'all set county policy.
That is not my question, Steve. I'm sorry, but I meant if we pass this and it turns out that $5,933 is not 1% of the money from the county aid fund, do we have to amend it?
I understand what you're asking now, Sue. I apologize for that. It depends on whether you're talking about overbilling or underbilling. The Association of Counties prepared that affidavit that you're looking at. So I'm assuming, without knowing, that's their bill.
And that they've already looked at what we got in our county aid fund?
That I don't know. I just know that they prepared the bill.
Well, if this ordinance is inconsistent with the statute, what happens?
Well, it depends on whether or not what the inconsistency is. If it's simply an accounting error and we overpay them, we certainly ask for a refund. If it's an accounting error and we underpaid them, I'm sure they're going to come to us with a bill in hand.
Okay.
Yes.
I'm sorry. Go ahead, Joel.
Madam Chairman, thank you. Maybe it would just be helpful if we had some clarification as to what that $5,900 actually gets the county. That might help resolve some of this.
There's several things that we get from the county. Not much legislation because we're one of the larger counties in the state, and so they represent, majority of the counties. But there's a list of things that they provide us, and we always have this discussion about, we would like them to do more for us than they really do, but that what they do, we can't go without because this risk management, we've had a couple of things in the jail that they've helped pay off. So, since I've been on the court, so we have received compensation from that in a larger amount than what we've paid in. So,
That'd be fine.
Yes, Butch.
We do have some questions here, but it's no question that we have so many employees, so many buildings, other facilities, so many miles of road, bridges. We can't go without this liability. It's just like it seems kind of complicated, but it's just about as simple as you can't afford to drive your car without liability. So, thank you.
Daniel Balls.
Yes.
Harvey Bowman.
Yes.
Rick Cochran.
Yes.
Robert Dennis. Lisa Ecke. John Furman. Ann Harbison. Tom Lundstrom. Eva Madison. Sue Madison. Joel Maxwell. Joe Patterson. Butch Pond. Bill Ussery.
Yes.
This ordinance is passed. Now we're into number 12. A resolution.
I will. A resolution discouraging the use of smartphones, iPhones, or similar personal communications devices during meetings of the Quorum Court or any committee thereof. Whereas, with advances in technology, cell phones have emerged into what are known as smartphones, allowing for instant communication between members of the Quorum Court, their spouses, friends, and constituents. And whereas, talking or texting on said devices are a distraction that should not occur when conducting public business. And whereas, engaging in such conduct creates the appearance of impropriety and that the Freedom of Information Act could easily be circumvented by the use of such devices during a public meeting. Now, therefore, be it resolved by the Quorum Court of Washington County, Arkansas, Article 1, the use of smartphones, iPhones, or similar personal communication devices by any member of the Quorum Court during any public meeting is hereby discouraged. Article 2, the Quorum Court encourages individual justices of the peace to turn off such devices during public meetings. Article 3, members of the Quorum Court should furnish to security officers contact information in the event there is an urgent need by any person to contact them.
Okay, and I move that this ordinance be passed.
I have a motion.
Second.
I have a motion and a second. Any discussion? Yes, Tom.
I just want to say that I was deeply offended by this article that appeared in the Springdale News. Deeply offended by it. I've been here 4 terms, 8 years. I have never sent a text to another Quorum Court member. Nobody has ever sent a text to me during a meeting, and I don't know of that ever happening. Can't say that it didn't, but I don't know of it. But this article says that several justices of the peace were clearly sending text messages to each other as the panel discussed public matters. I don't know who can prove that. I believe, I don't know where they got their information. I assume it's from Bill Ussery. And if it is, I think that Bill should name the people that are being accused of doing this so they can face the accuser. And I believe that proof should be submitted that it happened. The very idea that elected officials would carry on secretive conversations through electronic messaging is offensive to the idea of conducting the public's business transparently. That just does not happen. I'm going to tell you something. This court is made up of honorable people. And this article right here makes us look far less than honorable. The very last remark is, we applaud Ussery and Edwards for trying to clamp down on this disrespectful practice. I just don't think it's a practice. I don't believe it's ever happened. I was at the meeting the night the lady in the audience came up and spoke about it, and when she found out what was actually going on, she seemed very well satisfied with the explanations. As I mentioned to Steve a while ago, I'm an ordained minister of a church. I've got people out there that may want to text me right now and tell me my daughter was killed in a car wreck. Can you come and minister to the family? And I want to know that right now. And I don't think it's any less interruptive for that phone to vibrate right there and me take a quick look at it than it is for a deputy sheriff to have to walk in here and tell me that I've got a call coming in. You know, which one is most disruptive of the meeting? If I have something I have to answer, I get up and go back here to the kitchen to do it so that I don't disrupt the meeting by texting in public. The reason that woman saw the phones that night is because this was not there. We were sitting at tables. I don't think a soul in here can see my cell phone. Can anybody see it? So it's not disrupting. It's not having any impact on this meeting at all. this article is very accusative, and I just don't like it at all, and I really appreciate the opportunity to make my feelings known publicly on television, because a lot of people read this kind of stuff, and because it's in the newspaper, they just automatically believe it. And that's a big mistake to make as a citizen, because I would like to see somebody prove that this happened. Maybe they can, I don't know, but I want to see it. And I think the people who are being accused have the right to know that they're being accused personally. I think the accused always have the right to face the accuser, although this isn't a court of law. Now, I also recognize, and I appreciate the fact this is a resolution discouraging us from doing it. I personally, unless somebody passes an ordinance or some kind of law prohibiting me from doing it, plan to bring my cell phone. I don't plan to text Harvey or Rick or Joel or anybody else. I have it here. I'm over 75 years old. My wife is over 75 years old. If she falls and breaks a hip, she's got her cell phone in her pocket. I want to know about it right then, not after she goes through a bunch of people out here on the security desk. So I'm sorry, but I've got strong feelings about this particular issue. And Judge, I thank you for your time.
Yes, Robert.
Of course, I see it on the door not to use the phones, and I can, that's just common courtesy to turn your phone to mute and not use it. When we were talking about dates for the meetings, I started to reach for my phone and look at my calendar. Not to call someone, but that's where I keep my wife has got, we're going to Dallas 2 or 3 times here in the near future for surgery. And so I need to look at my phone, not for texting someone or calling someone, but to see the calendar. And I couldn't do that a while ago, and I think I got a conflict, but I couldn't say I had a conflict. So I understand what the purpose is, and I understand the freedom of information, but at the same time, a phone is now the device is, that's my day timer. I mean, used to we carried a day timer. Nobody would have thought anything about penciling something in a day timer, but now we put dates in our calendar, and that's the way I manage it. So I'd like to be able to reach for my calendar, but I didn't dare do it because of the sign on the door. So, thank you.
John.
Yeah, I kind of tend to agree with Tom. I mean, that was an editorial in the paper, and I was disappointed with it. I've served 3 terms here, and I can't say, prove or disprove any kind of action that people have taken on this court. But I'm confident that we observe the FOI, and my daughter is in 8th grade, and she's allowed to take her phone to the school, and she uses it sometimes. And I've got my calendar, and frankly, I just think that we should respect each other on the court, and I don't think that this resolution is a good way to start the year, frankly, because I don't. If someone sees someone texting from one person to the other, they need to tell someone, and that's our responsibility. And minus that, I'd like to just I'm going to definitely vote no on this resolution. Thank you.
Rick.
Well, I agree with you. This is not a good way to start our year. Tom, you really said it all. The accusations of impropriety towards this court are not well received. It's not that I don't think this is a good idea. I think we all practice this already. I don't feel this resolution is necessary, and therefore I won't support it. But I do support the ideal of openness in government that the FOIA affords us. And thank you.
Judge, I've been on the court now 2 years. I have never one time seen anybody be disrespectful and talk on the telephone during our meetings. I've seen people that had some kind of issue that they got up and left the courtroom to go handle the issue on the phone. And I've seen some people that respond to text. Most of us in this room have some business or personal interest that we get some text from time to time that may be kind of important. I'm like Tom. My wife is not a young lady anymore, and if something happens at home, I want to know about it. And so, guys, I guess I feel like this is more of a deal like Mother May I, or we're going to stop, hey, I can't give you a sign, don't do this thing, or yeah, go ahead. Are we going to eliminate body language? Are we going to sign language? Or what are we going to do next here with the ordinance deal if we're going to try to stop any cross-contamination or cross-communication with cell phones? I just, I think it's completely out of order. Thank you.
I just had one thought I forgot to make a while ago. The only person I have actually witnessed texting a quorum court member in this court, and I know this because I sat right next to the person receiving the call, and I see the guilty party smiling over there, is Karen Beeks texting Candy Clark, chair of the Finance Committee, saying, turn your mic on, or have people turn their mic on, or help her with some detail that she knew Candy wasn't aware of with regards to finance. Helpful issues. Had nothing to do with FOI and all the rest of that stuff. And I'm like, Rick, I respect all that. I really don't have any problem with the article. I mean, if it is being abused, I agree with them. What I disagree with is making these kind of accusations without one scintilla of proof that it took place, and making this quorum court look like a bunch of violators. Thank you.
Bill.
I apologize if I offended anybody, but I can tell you that whenever I was at that meeting, there were several people that were texting. I don't care if they were texting their mother. I don't care. It was very disrespectful in the manner in which it was being done, and several people in the audience noticed that. And where the people in the audience notice it to the point that they have to get up and say something, that's where something has to be done. And this ordinance does not in any way say that we shouldn't use those devices and that they're not an important part of what we do. The whole point of this ordinance is that we have a responsibility to be paying attention to what's going on at this table and not worrying about trying to talk to somebody else at the same time and missing what's going on. There's no need to name names because the people that know it. The people that did it, they know who they are. And whenever somebody asks a question that was clearly answered earlier, but they were busy texting and they didn't listen, then that's what this is all about. And again, we're not trying to say you can't use your calendar or you can't have it here, but it's just saying that we need to respect the judge and the people that are out here in the audience and focus on our responsibility here instead of things that are elsewhere that don't concern this court. That's the whole reason that this is being brought forth. And again, I apologize if I offended anybody, but it did get out of hand at that meeting in December, and that was what precipitated this. And so I'll let you all decide. But again, that's what the whole reason that it was brought forward. And again, I apologize if I offend anybody because that wasn't the intention. The intention is that sometimes we have to be brought in line and reminded that there are some things that are inappropriate. I mean, anyway, I appreciate it. Thank you.
I'm sorry that some people are offended by this, but I think we do not need to be texting during quorum court meetings. And I have observed this. Bill has observed this. We both sat on this side of the court, and we're not going to name names. We just want the quorum court members to be more professional. Now, it may have been only one or two meetings that was really out of control. And maybe they did have business that they needed to take care of. But I'm glad that Bill brought this ordinance forward. Now, whether it's going to pass or not, he's brought it to the table and said, we are professional people. We are here to do the duty of the county's people, and that we need to pay attention to that. And if we have personal business to take care of, we need to get up and leave the court to take care of it. You know, I can argue either way that some of you are opposed to this, but I'm glad it's been brought forward. Everybody's going to be aware of it, and if they need to carry on business, then I think they need to go somewhere in private and do that. Thank you.
So, do you have your hand up? Yes.
Thank you, Madam Chair. I think we got lots of mics on here. Most of us have other lives besides being a JP. This is a part-time job, after all. And I have over 30 tenants that are relying on me to provide them with shelter. And something has happened in the world of young people. They text. That's all they do. If it's the dryer that's broken, they text me. If a water heater springs a leak, I think they're going to text me, and you would see me fly out of this room if I had a water leak happening at a rent house. And I mean, even if the ordinance passes, I don't intend to follow it. It's not an ordinance, it's a resolution. Excuse me, I would follow an ordinance. But, I mean, I feel strongly enough about taking care of my tenants and my houses that I'm going to take care of it, and I will be discreet, and I will be brief. And I can sometimes manage two balls in the air at once. But, I mean, my tenants are so addicted to texting that I honestly fear the house could be on fire and they would text me. All they know to do is get a hold of Sue. And if I had to give them a security person's number as an extra step to get me, they might start calling the security man when the dryer broke. I don't think that's a reasonable solution at all. There are people at this table who work for national and international firms that are in multiple time zones that have obligations besides the obligations we have here tonight. And we all feel very deeply about the trust that the public has given us to do our jobs. And we do them to the very best of our ability and follow the letter of the law. But I've got a laptop here with me that's got instant messages on it that I just downloaded the Freedom of Information booklet so I can scan it or search it. I mean, you cannot take these out of our hands, and let us do our jobs. So I'm not really convinced that a useful purpose was served in bringing this. It has actually cast doubt on this court. But I am definitely a no vote and don't intend to follow it if it passes. Thank you.
Judge, I think that we talk about the calendars on our phone, their computers, their emails, or on and on it goes. Guys, we have to all recognize that we have to be careful about the assumptions we make from what we see. You know, not everything is what it appears to be. And I'd encourage the press and the people watching that they are aware of that there's a lot of other things going on. It may not be what it appears to be. So you've heard that old thing, if you break assumption down, you get a pretty good explanation of what happens when you make the wrong assumption. Thank you.
I'm going to call for the question.
Just one more quickie. I'm not offended by Bill. I'm offended by this article. But I don't know whether they misquoted him or not, really doesn't matter. But the article clearly says several justices of the peace were clearly sending text messages to each other. Now, just like Harvey said, sitting over here next to Candy when we'd be involved in finance and budget, I would have my phone on the calculator trying to figure out the numbers we were dealing with in that conversation. Well, I could drag a calculator down here and set it on the table, but there's no need because I got one. Doesn't make any noise, but it could look like I'm texting. I agree with that. But I think that's what the public needs to know, that there's more functions to these phones than just texting and calling, and they all know that. And this woman was well satisfied that night with the explanation she heard. Eva Madison, if I understand it right, has another firm in California, which are 2 or 3 hours earlier than we are. So she was getting a text message that night from somebody in her firm that she replied to. Doesn't mean she didn't hear what was going on in the meeting and so forth, I'm sure, because I know how articulate she is. But, Madam Chair, I appreciate the time, and I will not
We've had someone
support this.
call.
Thank you, Madam Chairman. I appreciate it. I understand the dilemma. I understand the offense that you took. And my name is Lorraine O'Neill. I live at 3001 West Weddington Drive, apartment 82. And I, too, can see both sides of the issue. But I, too, have been in the employ of someone who would insist that phones be turned off and put in your locker. None of us are so important that someone can't wait for 1 hour till we conduct our business. And I appreciate the fact that we're all older and that there are people depending on us and that we have become very addicted to all of the functions that are available. I carry a little phone. It's got a calendar. I use it all the time. I understand that. But when you're here, your focus should be on the business at hand, and everything else will just have to wait.
Thank you, ma'am.
Daniel Balls? No. Harvey Bowman? No. Rick Cochran? No. Robert Dennis? No. Lisa Ecke? No. John Furman? No. Ann Harbison? Yes. Tom Lundstrom? No. Eva Madison? Sue Madison? No. Joel Maxwell?
No.
Joe Patterson? Butch Pond?
Yes.
Bill Essery?
Yes. This resolution has failed. I think there's been a lot of good discussion on this tonight. I think there's been some points that's been made, some things that have come out. I'm sorry. Oh. I think some points have been made, some discussion, and I feel like some things, excuse me, I think there is some things that makes us all more in tune to what we're really doing. A lot, that's me also. I don't even bring my phone to my desk. I put mine in my purse back here because I know it will ring and I can't answer it. But anyway, I appreciate the conversation. I appreciate the discussion. Thank you, Bill, for the resolution. I think it has made people more aware of what we're talking about. Thank you. Excuse me. Steve, will you read this, please? I'm.
We're on item 13, and Ann is the sponsor.
Okay, we have a resolution to put, for an election, to put the rural fire department dues on the ballot. And if they approve that, then they go on their real estate bill. Would you please read the ordinance?
I think I'm going to.
An ordinance calling a special election on the question. Oh, sorry. Y'all can move to suspend the rules. Before you do that, let me say this: you're going to have to do this in 3 consecutive. In order for it to comply with the state statute, you need to do it at 3 consecutive meetings because by statute you have to have the meeting within 30 days, or the election within 30 days of it being read. You're looking at me like I'm crazy, Karen. 60 days, I'm sorry. And they intend to have it in May, as I remember.
So.
I am crazy. Anyway, we can't pass it. We can't move it up tonight for the election to take place as the West Fork Fire Department wants it. But if the sense of the body is that they wish to suspend the rules and place it on first reading by title only, I'm happy to, or Judge, that's up to you.
If you will go ahead. What we'll need to do is, everyone's in favor of doing this, then we'll just move it on to the next meeting for the next year. So,
but you still need to motion.
You still need a motion to read it.
I move that we read it by title only to place on.
Second.
Is that suspending the rules? And is that right with the second? Yeah, thank you. Judge, you have to
I'm
call for a
sorry.
vote on that. That's okay.
Can we just do it? All in favor, say aye. Opposed, same side. I'm sorry.
Judge, you all right?
Yeah, I'm okay.
Okay, an ordinance calling a special election on the question of the levy of the annual dues of the West Fork Rural Fire Department and prescribing other matters pertaining thereto. Thank you.
Okay, so this will be moved forward to the next meeting, and we'll continue this for 2 more months after tonight, and then that will get our date so that it'll be worked out so the election can be in June for the fire department. An emergency ordinance ratifying a conditional use permit granted by the Planning and Zoning Board. That's John.
Caught me off guard. And I wasn't texting, I promise. Steve, can you read this ordinance, please?
14.1, an emergency ordinance ratifying a conditional use permit granted by the Planning and Zoning Board. Whereas the Planning and Zoning Board granted a conditional use permit on November 6th for Baldwin Cell Tower, and whereas immediate ratification is necessary by the Quorum Court to prevent undue delay and expense to the applicant, and whereas ratification will not affect any appeal rights any person may have, now therefore be it ordained by the Quorum Court of Washington County, Arkansas, Article 1, that the conditional use permit for the Baldwin Cell Tower is granted by the Planning and Zoning Board is hereby ratified. Article 2, Emergency Clause. It is hereby determined that it is in the public's best interest for this ordinance to be effective immediately, and the general health, safety, and welfare of the citizens are affected by such for the reasons as set out above. Therefore, an emergency is declared to exist, and this ordinance shall be and is effective from the date of its passage.
Thank you, Steve. I have a couple questions before I...
That's why I brought Juliet forward.
Okay, thank you, Judge. This being the cell tower, and I realize that they're controversial, but it sounds like the people that appealed it have stopped. Is that what you're...
Yes, sir. They have withdrawn their appeal. I spoke with, well, not them personally, but they had an attorney representing them who was also the attorney that filed their appeal. And we spoke, and the applicant for the tower and the appellant were able to work out an agreement that changed the style of the tower slightly to where it'll now just be, they call it a flagpole or a monopole with the internal antennas. You've probably seen them around town. Some of them you can see the antennas hanging externally, but this will just be the pole that just looks like the blank pole with the internal antennas. And the appellant was in agreement that would be enough, just the style of tower change would be enough to drop the appeal. And if you did read the attachment that goes through 14.2, that goes through the conditions that were originally approved by the Planning Board for this, we are recommending that all those be the same with the addition to the first condition stating that the style would be the style that was agreed upon.
So I have one more follow-up question,
Go right
Judge.
ahead.
So if by making this the emergency ordinance, it would go into effect right now, but I get a little concerned about maybe potentially public perception that we're just pushing this through in case someone else, didn't know about it or something. I mean, are you recommending that we do this emergency clause, or is this from the applicant?
No, that's the way we always do conditional uses. And the appeal time period has run.
Okay.
They had 30 days from when the planning board approved it on November 6th. And in that 30 days, there was only one person who appealed. And so all the other people had a chance. And then we notified neighbors of the pending appeal. And then when it was canceled, we notified them of that and also let them know that it would be on the agenda tonight for ratification.
You did? Okay. Okay, thank you, Juliet.
Yes, sir.
Well, I'm going to make a motion that we approve this ordinance.
I have a motion and a second. Discussion. Rick?
Juliet, how many people were notified in that area? How many residents? Do you know offhand?
I'd have to look.
Approximate number.
My brain tells me something around 35.
Okay, so you've got only one person out of 35 that had a problem and it's been resolved?
We had several people that had questions or comments, but only one person who appealed.
Okay,
yes.
Thank you.
Yes, sir.
Any other discussion? Any public comment? With no further comments, Karen, would you call the roll, please?
Daniel Balls. Yes. Harvey Bowman. Yes. Rick Cochran.
Yes.
Robert Dennis.
Yes.
Lisa Ecke. John Furman. Ann Harbison. Tom Lundstrom.
Yes.
Eva Madison. Sue Madison. Joel Maxwell. Joe Patterson. Butch Pond. Bill Essery.
This ordinance is passed. The next thing we have is an emergency ordinance ratifying conditional use permits granted by the Planning and Zoning Board. Julie, I got you for that one too. John?
Thank you, Judge. Steve, can you read 15.1, please?
Yes, sir. An emergency ordinance ratifying a conditional use permit granted by the Planning and Zoning Board. Whereas the Planning and Zoning Board granted a conditional use permit on January 8th for Cook's Rentals, and whereas immediate ratification is necessary by the Quorum Court to prevent undue delay and expense to the applicant, and whereas ratification will not affect any appeal rights any person may have, now therefore be it ordained by the Quorum Court of Washington County, Arkansas. Article 1, the conditional use permit for Cook's Rentals granted by the Planning and Zoning Board is hereby ratified. Article 2, emergency clause. It is hereby determined that it is the public's best interest for this ordinance to be effective immediately, and the general health, safety, and welfare of the citizens are affected by such for the reasons as set out above. Therefore, an emergency is declared to exist, and this ordinance shall be and is effective from the date of its passage.
Thank you, Steve. Seeing that this is the time of appeal is still in effect, and that staff is recommending that we go ahead and pass this, I'm going to make a motion to pass 15.1.
I have a motion. Do I have a second?
Second.
I have a motion and a second. Any discussion? Any public comment? With no further comment, Karen, would you call the roll, please?
Daniel Balls.
Yes.
Harvey Bowman. Rick Cochran. Robert Dennis. Lisa Ecke. John Furman. Ann Harbison. Tom Lundstrom.
Yes.
Eva Madison. Sue Madison. Joel Maxwell. Joe Patterson. Butch Pond. Bill Essery.
This ordinance is adopted. Do I have any other business to come before this court tonight?
I have something.
Okay. Jump up here.
I wanted to introduce Carly.
I'm sorry.
She is the court coordinator, and Jessica, many of you knew Jessica. Jessica's went to the university now, so she's working over there. So Carly is Jessica's replacement. So anything that we can do to help any of you, just email either one of us or both of us. So that's it.
Thank you, Karen. Do I have any citizens' comments? Yes, go ahead.
First, I want to thank Carly for turning up the heat. I'm almost an icicle there. I wanted to know if our technology is such that things on the website could be PDFs rather than scanned documents, because it's hard to work with them as a scanned document.
I can't tell you that. You'll have to talk to let.
Could you work on it? Maybe.
I thought they were scanned as a PDF. That's what I.
Well, the agenda that opened up for me was kind of wonky.
Sue, work with Karen.
Okay, thank you.
She'll help you. Do I have any citizens' comments? Come forward and introduce yourself, please.
I'm Dan Holtmeyer with the Democrat Gazette now, and I just wanted to, mostly for new people, just to make it clear, the article that Tom was talking about was an editorial written by an editor. It was not me. And so, just in general, if you're ever annoyed by something you see in an editorial, just know that.
Thank you, Dan. If no other, do I have a motion to adjourn? It's Karen. Okay, all in favor, say aye. Aye. And I apologize for having a coughing fit. So.